Two.
Who?
Dear Lordship, my document is my unwell Lordship, but then also Lordship, this matter needs some long deliberation. Lordship. Can this matter be any day listed as a first item? Any date, Lordship. Otherwise, it will not be completed, Lordship.
No, why are you apprehensive?
No,
If you are ready to
already,
take up,
Lordship,
we can
some
take
days
it up.
are being because they are raising an issue. My other other
Who is
side.
for the respondent?
I am for the respondent.
Yes.
Bivas Patak, Lordship.
Yes. So pleadings are complete.
Completed, Lordship.
All right. A joint request matter stands adjourned. We listed on 30 August.
But on that day, it not.
You make a mention. You are entitled to make a mention for upgrading the matter
Lord.
on 30.
Lordship, yeah, I have another prayer, Lordship. Item number 19, Lordship.
Yes.
In this case, Lordship, I'm not prepared, Lordship. Can it be
Who's for the respondent?
respondent thing?
You are for the respondent. Any objection?
No objection, Lord.
Item 19 adjourned at the request of Mr. P. Sharma, the counsel for the petitioner, to be listed after 2 weeks.
Highly
Yes.
obliged.
Yes.
It is my lord. Items 23 and 24. While I am for the petition on matter, we have to file affidavit in reply in the case it is gone for vetting. While 1 week's time may be given.
Who's for the petitioner?
While I am for the
Who's for the respondent?
my lord. Consent has been taken, my lord.
23, 24 at the request of counsel for the petitioner. Matter stands adjourned for 2 weeks. It is submitted. Consent of the counsel for the petitioner has also been obtained. List after 2 weeks.
May it please, my lord. May it be after 1 week. If it pleases, my
All right, list on 30.
my
30.
lord. Not date, my lord.
Why?
1 week.
Why?
Instructions are
We are giving you 2 weeks. We are listing it on 30. 30 August.
my lord. My
Yes.
Please, your Lordship. Lordship, I beg to mention item number 14. Lordship, 2 weeks time may be granted to file affidavit. We have received the otherwise comments,
Who's
Lordship.
for the petitioner?
It is my Lordship. I have taken consent of him. The Lordship, he has.
Mr. Rahul, you are appearing in the matter? Any objections? Item 14?
no, my lord. No.
Item 14 at the request of Colonel CGC R. Devi stands adjourned for 2 weeks to file the affidavit in opposition.
Lordship.
Objections. Counsel for petitioner does not object to the prayer made after 2 weeks. Yes.
Please, your Lordship, I beg to mention item number 12 with the consent of petitioner. As we adjourn this matter to the
You are for the
filing
respondent.
affidavit.
You are for the respondent.
Yes, respondent number 1 and 2.
Who's for the petitioner?
I am put of it.
Any objection?
No, my lord.
Item 12 with the request of learned counsel for the respondent. What is your name?
K. Kolita.
A. Kolita. Matter stands adjourned for 2 weeks, enabling them to file the objection. That's straightforward. Counsel for the petitioner, Mr. S. Soikia, does not object to the prayer made.
Obliged, Your Honor.
Consider of the other side, I beg to mention item number 13 and 22. For 13, I am the respondent here.
Who's for the petitioner? Counsel for petitioner is available.
We have taken the consent method.
And
2 weeks time-
32.
22.
Huh?
Yes, sir. 22.
22.
Yes.
At the request of counsel for the respondent. Respondent.
22, I am for the petition.
Item 13 at the request of counsel for the petitioner. Matter stands adjourned for 2 weeks. Sorry, respondent. It is submitted that consent of the counsel for the petitioner has been obtained. Your name?
W. Ahmed.
W. Ahmed appears for the respondent in item 22. Counsel for the petitioner prays for 2 weeks time. Prayer allowed. List after 2 weeks.
Much better.
Yes.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 17. I am for the respondent numbers 2 to 5, Airport Authority of India. The written objection, the affidavit in opposition has been prepared, my lord, but it has been given to vetting. 2 weeks time may be granted, we'll file the same. Is for the date may be fixed. That may be done.
Matter adjournment is sought for by Mr.
I am sure, my lord.
N. Chaudhary, learned counsel, appearing for respondents 2 to 5. 2 to 5.
2 to 5, my lord.
Who submits that the objections are being prepared and likely to be filed within a short date. Mr. S. Islam.
Yes.
appears for the petitioner. Let the matter be listed again on 6th February, 6th September. 6th of September. Our learned counsel for the petitioner. Its application is filed for appointment of an arbitrator in respect of the dispute which is arisen between the petitioner and the respondent in connection with the agreement for development of land executed by and between the petitioner and the respondent on 1st February 2020. Learned counsel for the petitioner has referred to the clause 15, which in the agreement which reflects that disputes are to be resolved by a way of arbitration. However, in spite of the respondent being called upon to appoint an arbitrator, same has not been done accordingly. The writ petitioner has approached the court filing the application under section 11(6). That notice be issued returnable 3 weeks. Steps on respondent, sole respondent by usual course and registered course within a period of 1 week. Matter being listed after 3 weeks.
I have served a copy, my lord.
You have served.
Yes, my lord. Sir,
Dusty,
Gogoi
Dusty is also permitted.
What happened today, I don't know, Gogoi. He cited them decision also, and I have a counter decision.
No, matter has come for the first time.
No, my lord, second time.
Huh?
Earlier order was
Item number,
2 weeks. Item number 1.
this is arbitration petition 28.
Yes, my lord.
There is no order here.
Not 28. 25. What am I done with it?
No, we have 28.
28.
Do you have the cause list?
Okay.
Do you have the cause list with you?
Huh? What number?
आवाज को क्या होता है?
Oh, no. Yes, yes. Another item is there. The notice has to be given. In this case, nothing has to be. Sorry, my lord.
Yes, who appears for the petitioner?
I appear for the respondent.
None appears for the petitioner. None appears for the petitioner. Mr. Gautam appears for respondent.
124, Your Honor.
In the interest of justice, matter be deferred to be listed again on 30 August.
As per the last order, Lordship, we have taken steps upon the respondent 3 and 4. Parties in respect of it is they have received, my lord. The 1, 3 and 4. 1. Lordship may kindly.
It is submitted by Mr. Council hearing for the petition. Where did that steps have been taken on respondent's number 3 and 4.
Yes.
3 and 4. By registered post,
Yes, my lord.
the relevant requisites.
Dusty was also there, my lord.
No, this is for registered post.
Registered.
Have you taken Dusty also?
Yes, my lord. Dusty was also taken.
Where is that affidavit?
Affidavit. No affidavit filed, my lord, but
No, you have to file an affidavit saying that you have taken steps on Dusty. He submitted that step requisites for issuance of notice by registered post have been deposited before the registry counsel to the petitioner as to the court. The receipt issued by the registry. Stop. It is submitted that the deposit was stopped. It is submitted that from the particulars received from the registry of the court, it is evident that copies have been served on the respondent on 29th of July 2024. Stop. That apart, counsel for the petitioner submits that steps by registered post have by Dusty has also been effected, but no affidavit has been filed. He therefore submits that the matter be deferred and an affidavit of service will be filed within 2 weeks. Yes, Mr. Deka.
I was appearing for respondent 1 and 2.
Mr. Deka, what is your full name?
A Deca.
A. Deka appears for respondent 1 and
R does, my lord. 5674567.
2. Mr. R. Das appears for 5, 6, and 7. You want to file an
Yes, Lordship.
objection?
Yes.
Have you filed?
No, not yet, Lordship. 2 weeks
Re-
may be
The
granted.
respondents submit that 2 weeks be granted for filing objection to the matter. Prayer made is not objected to by the council. Accordingly, the matter will be listed again on 6th of September. Yes, item 4, item 4. Earlier was item 3.
So 4 was. No, it is 4, my lord. Arbitration petition 6 of 2024.
आपने कौन सा फाइल किया?
आपण देखो 4 मत. Not 4 मत.
हाँ?
4 मत.
वो आगे वाला पिटीशन कौन सा है? In item 3, arbitration petition 35, who appears?
No, it is not mine. We are for 4. 6 of 2024.
Okay, anyone for 3? Yes. What is your submission here?
We have taken steps 3 times. In fact, we have done paper publication.
Yes.
We have taken steps to respond anytime and it's answered. And in fact, we have done paper publication also.
Office note reflects no steps.
We have taken steps
When?
in 2000.
How? Steps for what? Through registered post.
Yes, sir. And by Dusty,
Have you filed an affidavit?
No.
After Dusty?
No.
Learned counsel, what is your name?
BP Sharma.
BP Sharma.
Yes.
submits before the court that steps have been taken. However, the office note does not reflect the same. He further submits that step by Dusty has also been effected. However, no affidavit of service has been filed before the court. Let the matter be listed after 3 weeks. Office to verify the steps stated to have been undertaken by the petition. The petitioner will also file the affidavit of compliance in respect of Dusty service stated to have been undertaken on the respondents list after 3 weeks.
Alright.
Yes, item 4, we have already passed that order. Yes.
Very pleasure, Lordship. Matter in this case, kindly see Annex 1 page start from 10 to 27, my lord. Petition was allowed, my lord, and petitioner was granted disability pension, my lord. But, my lord, I am aggrieved of para number 21, my lord. Here, my lord, it is held that grant of area pension shall be restricted to a period of only 3 years prior to filing of this petition. Petition was filed in 2022, my lord. So, and petitioner was discharged from service in 2003, my lord. So, he will get from 19 only, and already he is a disabled person, my lord. And my lord, kindly see, my lord, in para 19, my lord has held that the circumstances of the present case are similar to writ appeal number 332 of 2021, my lord. So, in this case also, no such, my lord, observation was given, my lord. And my lord, delay was not because of me, my lord. In the judgment, it is held as because my lord, the delay by the respondent only, because I am submitting, my lord, pension document again and again because they have asked me, but they have not released. My disability was examined again and again, but they have not released. So, under compelling circumstances, I approach this honorable court.
Yes, what do you say?
Lordship, let notice go because only
Part,
today is
the
the
council
first day.
for part. This is the review petition seeking review of the judgment and order dated
23 January 24.
23rd of January 2024 passed by this court, WPC 3093 of 2020. The counsel to the petitioner submit that his writ petition was disposed of and was allowed in favor of the claims raised by the writ petitioner. However, the grant of invalid pension under Rule 38 of CCS pension rule was held to be payable to the petitioner. The arrears of pension was held to be payable to the petitioner to a period from a period of only 3 years prior to filing the writ petition. So, the counsel to the petitioner submits that this restriction ought not to have been granted, as this as in the as this writ petition upheld the claims of the as the judgment and order upheld the claims of the review petitioner as the writ petitioner, and therefore once his claim is upheld, the restriction of grant of arrear of pension from 3 years prior to filing the writ petition ought not to have been granted. Stop. That apart, the delay which had occurred cannot be attributed to the writ petitioner / the review petition, and therefore the review petition has been filed seeking review to the extent the grant of arrear pension was directed to be restricted to a period of only 3 years prior to filing of the writ petition. Let notice be issued. MS P. Sharma, learned CGC, appears for the respondent and accepts notice. Since the learned CGC appears, notices are waived, extra copies be furnished within a period of 1 week from today. Matter be listed after 2 weeks, 3 weeks. 3 weeks.
Hello.
Please, your lordship, kindly pass over the matter for the time being. Much appreciated.
Main file with it.
That is,
Yes.
the justice service has been affected upon the respondent number 3, lordship.
What is this IA for?
I is for stay of the arbitration petition. So today we are not pressing for the IA, lordship, only for the arbitration. Getting service, lord. The justice service has been affected upon the respondent number 3. I'm praying for some time, lordship, to file the affidavit regarding justice.
Learned counsel for the petitioner submits that justice service has been effected on the respondent number 3. However, he prays for a short date. He prays for some time to file the affidavit of compliance and bring it on record. So, yes,
I'm appearing for respondent 1.
Mr. D. Das appears for respondent number 1.
Lordship, I'm appearing for respondent number 2, and today I have filed my wakalat number.
Your name?
A.K. Roy.
Mr. A.K. Roy appears for respondent number. Let the matter be listed after 2 weeks, enabling the respondent, enabling the petitioner to file the affidavit of service. Affidavit of compliance for service of notice of respondent 3. Stop. The other respondents may also file their objection / affidavit to advise in the meantime. This is in the main petition. IA be listed along with the arbitration.
Yep. Okay. The service has been completed.
Hmm?
Service has been completed. We have taken steps.
So you filed some IA
Yes,
IA for amendment.
amendment of the petition.
Yes.
There's no objection.
Heard learned counsel for the parties. This IA has been filed by the petitioner seeking amendment of the arbitration petition, being arbitration petition 28 of 2022. Where are the amendments sought for?
The file, the
The-
sign-off number
The counsel for the petitioner 6, the following submits that the following amendments are necessary. Para 6, Para 7. He submits that due to inadvertent mistakes, the correct averments and statements were not made in the application petition, and therefore the same is required to be amended. Para. Notice in the matter was issued on 15/7/2024. Mr. A.K. Dotto appears for all. CTC appears for all the respondents. Mr. Dotto does not object to the prayer made seeking amendment of the arbitration. Accordingly, his IA stands allowed. The upon taking into consideration the submissions of the counsel petitioner and upon perusal of the IA, this court is of the view that the amendments can be allowed. Accordingly, following amendments as reflected in the IA are allowed to be incorporated in the arbitration petition 28. Para 6 and 7 repeat again. IA accordingly stands allowed and disposed of. The amended arbitration petition will be filed within 2 weeks from today. The arbitration petition You write in view of the order passed in ISO and so amendments sought for are allowed. Petitioner will file the amended arbitration petition within 2 weeks from today and serve copies on the respondents just after 2 weeks. Yes,
My lord, in this case, readings are completed, my lord. And your lordship may kindly come to page 55, arbitration clause is there.
55.
Yes, my lord. Clause number 25. Settlement of disputes and arbitration.
Yes. Yes, please.
Yes, so except where this clause 25 says, my lord, except where the otherwise provided in the contract, all questions and disputes relating to the meaning of the specification, design, drawing, instruction herein before mentioned, and as to quality of the workmanship or material used on the work, as to the other question, claim, right, matter, or thing whatsoever in any way arising out of or to the or otherwise concerning the work or execution of or failure to execute the same, whether arising during the progress of the work or after the cancellation, termination, completion, or abandonment thereof, shall be dealt with as mentioned herein. If the contractor consider any work demanded of him to be outside the requirement of the contract or dispute any drawings, record, or decision given in writing by the engineer in charge, or if the engineer in charge consider any act or decision of the contractor on any matter in connection with or arising out of the contract or carrying out of the work to be unacceptable and is disputed, such party shall promptly within 15 days of arising out of the dispute request the chief engineer CPM, or where there is no chief engineer CPM, request the additional director general, special director general, who shall refer the dispute to the dispute redressal committee within 15 days, along with a list of dispute with amounts claimed, if any, in respect of such dispute. Now here, lordship, as per the clause 1, my lord, I invoked this clause 1 and I demanded for constitution of the dispute redressal committee, my lord. At page,
No, first take us to the clause properly. So what is the first step?
first step to, if there is a dispute, to invoke this clause 1 for appointment of dispute redressal committee.
Yes.
Now, in this case, my lord, there was a claim and which was not paid by them. Then I invoke this clause 1, my lord,
Hmm.
at page 102, my lord.
Hmm.
But within 15 days, time is given for the constitution of the dispute redressal committee. But they failed, my lord. Rather, after expiry of the 15 days, they wrote a letter for rewriting the agreement. And it is my right. I declined to rewrite the agreement. So now this exhausted, my lord, as they failed to act in accordance with the agreement. Now second portion, my lord, may come.
Yes.
Clause number 2, my lord.
Hmm.
Dispute or difference shall be referred to adjudication through arbitration by a tribunal having sole arbitrator, where claim amount is rupees 20 crore or less. Where claim amount is value is more than 20 crore, the tribunal shall consist of 3 arbitrators as above. The requirement of the Arbitration and Conciliation Act and any further statutory modification or reenactment thereof and the rules made thereunder and for the time being in force shall be applicable. It is a term of the contract that the party invoking arbitration shall give list of the disputes with amount claim, if any, in respect of the each dispute and along with the notice for appointment of the arbitrator. and giving reference to the decision of the ADC, HDC on finding recommendation of the DRC. So accordingly, my lord, I invoke the arbitration clause. The notice was received by them. They failed to appoint the arbitrator. In other words, they failed to act as required under the agreement.
Yes.
Now, as per section 12(5), my lord, they cannot appoint the arbitrator. Party of the agreement cannot appoint the arbitrator.
Yes. What is their stand in the affidavit? What do you say?
According to the contract agreement also, they have to place the dispute before the DRC.
Who is to appoint for the who is to constitute the dispute resolution?
Page 50, 50 of it, WPC, writ petition, Your Lordship.
No, you come to
Clause
the
50.
you come to the contract clause.
Yes, Lordship. See, Your Lordship, the 3-member committee, Your Lordship, Chief Engineer chairman, and
Yes.
other 2 members, Your Lordship.
Then what happened?
Your Lordship, first, he has to place the dispute before the DRC, and within 60 days, the DRC has to
Show
resolve
us
the
from
issue.
show us from the clause that he
Yes,
has to place.
But he does not place any his dispute here before the DRC, Your Lordship.
Mr. Counsel, I'm
Okay.
asking you to point out the relevant portion of the clause where it requires the contractor to place the dispute.
Your Lordship, yes, okay. Clause 25, Your Lordship.
25.
Clause 25, page 56, Your
Yes,
Lordship.
yes.
25 only. If the married daughter, if the contractor consider any work demanded of him to be outside the requirement of the contract or dispute any other drawings, records, or decisions given in writings by the engineering chief, engineer in charge, or if the engineer in charge consider any act or decision of the contractor or any matter in connection with or arising out of contract or carrying out of the work to be unacceptable and in dispute, such parties shall promptly within 15 days of the arising of the dispute request the chief engineer slash CPM, or where there is no chief engineer or CPM, request the additional director general slash special director general, who shall refer the dispute to dispute redressal committee within the DRC within 15 days, along with a list of dispute which amounts claim, if any, in respect of each such dispute. The dispute redressal committee gives its decision within a period of 60 days, extensively by 90 days by consent of both the parties from the receipt of the reference from CE/CPM/ADG/SDG. The constitution of the dispute redressal committee shall be indicate the Schedule F, Your Lordship. There is this is a part of this contract agreement, Your Lordship, and provided that no party shall be represented before the dispute resolution committee and by the advocates slash legal counsel, etc. Next, Your Lordship, the DRC will submit the decision of the concerned ADG SDG for acceptance of ADG slash SDG in the time limit of 30 days from the receipt of DRC. Decision will be convey acceptance of or otherwise on the said decision. If the dispute resolution committee fails to give its decision within the aforesaid period order, or the ADG slash SSD fails to give its decisions in the aforesaid time limit, or any party is dissatisfied with the decision of the dispute resolution committee, ADG as thereafter, and the party may, within a period of 30 days from the receipt of the decision of the dispute resolution committee or expiry of the aforesaid time limit, available DRC may give notice to the chief engineer and CPM, CPW in charge of the work. If there is no chief engineer, CPM, the additional director general, special director general concerned, or if there is no additional director general or special director general, the director general of CPW for appointment of the arbitrator. If failed, Your Lordship, or on prescribed pro forma as per the appendix 17 under the intimation of the other party. Next para is important, Your Lordship. It is a term of the contract that each party invoking the arbitration must
exhaust the aforesaid mechanism, your lordship. This is the DRC. And or settlement of the claims dispute prior to the invoking arbitration, your lordship. So he has to place these grievances before the DRC, your lordship. If DRC fails to resolve the issue in 60 days, extensively 90 days, then he has to invoke in this your lordship, arbitration, your lordship, without going through the process, your lordship. It is a contract agreement. He has a signatory of this contract agreement, your lordship. Once he has agreed, your lordship, later on he said that straight away he go to the lordship arbitration, your lordship.
Yes.
My lord, my submission is twofold. First of all, my lord, this agreement was terminated by them. Now every clause has gone. After termination, the entire provisions of the contract got perished with the termination. What is survived by only the arbitration clause? Part 1 is not the arbitration clause. Part 2 is the arbitration clause. Now, one second, my lord, submission is that, my lord, I invoke the arbitration, this DRC
What is
clause.
the basis of this argument that the entire contract
Yes,
is not to be enforced except for the arbitration clause?
as per the section 16 of the Arbitration Act.
Let us see.
What the statute provides, my lord. Section 16, my lord. Competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to existence or validity of the arbitration agreement. And for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement, independent of the other terms of the contract. So clause 25(2) is the only arbitration agreement, not the other clauses.
Please come again.
An arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. So the clause 25(2) is the arbitration agreement. Clause 25(1) is not the arbitration agreement. So it will be treated independently, irrespective of the other terms and conditions of the contract.
No, clause 25 has been shown to be the arbitration, settlement of disputes and arbitration.
Yes. So there is a mechanism for settlement of dispute through arbitration, and then the arbitration will come.
That's right.
Yes. Now they have terminated the contract. So first part has gone. Now, irrespective of that, my lord, apart from that, this clause, I am again coming to clause, my lord, 25(1). If the contractor consider any work demanded of him to be outside the requirement of the contract or dispute any drawings, record or decision given in writing by the engineer in charge, or if the engineer in charge consider any act or decision of the contractor on any matter in connection with or arising out of the contract carrying out of the work to be unacceptable and is disputed, such party shall promptly within 15 days of the arising of the disputes request the chief engineer, CPM, or where there is no chief engineer, CPM, request the additional director general, special director general, who shall refer the dispute to redressal committee within 15 days. So I requested for constitution of the DRC, but within 15 days they failed. Now,
that is what we are asking you. Where is your request for?
Yes, I am coming to that matter. At page, my lord, 102. Letter dated 15/11/2022. Now, at page 106, my lord, prayer is there. It is therefore we request your good self to kindly refer the aforesaid dispute to dispute redressal committee within 15 days from the date of receipt of this letter in terms of the agreement, as in message, they are in an oblige.
So you are required to raise a dispute when? Is there
When there is a
agreement?
dispute, I am required to request for the constitution of the DRC when there is a dispute. There was a claim and there was a denial. So dispute is there.
You are to raise it within 15 days.
Lordship.
I raised the 15. This is not the question. They have to appoint the DRC within 15 days.
No, that's all right. But
What-
you have to raise the dispute within 15 days.
Lordship.
I have raised.
So when did the dispute arise?
Dispute arise, my lord, on 8/9/2015
From which document you say?
at page 86, my lord. Rather, this is dispute is there.
8/9/22.
No, yeah.
20.
At page, my lord, 98, my lord, dispute is. They have denied my claim. Annexure 31, page 98. 2/11/2022. And on 15/11/2022, I raised the request for appointment of the DR. Now, within 15 days, they have to appoint the DRC. But they, instead of appointing, they wanted to rewriting the agreement. At page 33, my lord. With reference to the above cited subject, it is stated that letter dated reference is received in this office on 30/11. It is admitted fact. So within 15/12/2022, they have to appoint the DRC. Instead, they are writing a letter on 1/12/2022. Thereafter, 15 days time expired. Instead, on 9/12/2022, page 109, my lord.
When were you intimated about termination?
By lodging my final claim. At page 90,
90.
they have terminated.
Yes, sir.
So,
When were you intimated?
Yes, yes.
I lodged my final claim. Once it is terminated, there is no need to again write any letter.
No. When was it terminated? When were you intimated?
By this page 90, my lord, and except 29.
510.
Final claim.
Now, this is the final claim you have raised.
Yes.
When were you intimated that the contract has been terminated?
By this letter itself.
This is the letter written by you.
Oh, they, my lord, they have determined on page number 82, my lord. Yes.
80?
82, annexure 23. On 16/8/2022, page 82, my lord. They terminated the contract. Despite the fact almost all the work was completed.
So 16/8.
Yes,
Yes, Lordship.
So then within 15 days, you are
No, my
supposed to raise.
no, that is not a requirement.
Why?
16/8/2022, they terminated my contract. Now within 3 years, I have to lodge my claim, or I have to make my claim as per the limitation. 3 years limitation is there.
No. As per the arbitration clause itself,
Arbitration clause is different thing. But as per the limitation act, I can raise the claim within 3 years from the date of determination of the contract or termination of the contract. Now the this 15 days requirement for issuing the notice for appointment of DRC is from the date of the dispute. Now, when the dispute will come, my lord, when there is a claim and there is a denial. Without denial, there cannot be any dispute. So here there is a claim at page 90, my lord. And this claim was rejected by them on 12/2/11/2022. So now dispute has arisen.
Your work measurement took place on which date? Measurement of work after termination.
After termination, there is a after termination, they issued a letter for rectification of defect at page 88.
You are referring to page 90. Page 90, you said you have raised a claim which was
Yes,
denied.
yes,
And therefore, thereby a dispute has arisen.
yes.
Now, in order to raise a claim at page 90, here the work you have undertaken is required to be measured.
That
Unless it is measured, on
that-
what basis will you raise a claim?
Not under section 11, this is not the requirement of the law. Because this
We
is
are trying to understand the import of the section 15 or 25, that arbitration clause. That's all.
yes. Your lordship may come to page 89, my lord. Handing or taking what took place of keys
On which date?
at page 89 and Annexure 28.
No, you tell us there must be some measurement. Otherwise, how will you raise the claim?
That, my lord, the arbitrator will call the record measurement book.
You know it. You are the claimant.
Yes, yes, my lord.
You have raised the claim on 510,
Yes.
saying that these are my claim. On what basis have you raised unless it is measured?
My claim is not only for the work done. My claim is for breach of contract. My security money is there. My performance guarantee is there. They have forfeited because of the termination. So at this stage, my lord, these records are the matter to be decided by the arbiter, my lord.
We are not deciding on that. We are
Yes.
trying to understand whether you have complied with the arbitration clause, because your submission before this court is only the arbitration clause survives, everything else
Yes,
is not to be looked into.
yes,
Now, this arbitration clause has as a precondition which needs to be satisfied, that you have to raise a dispute.
yes,
So
That-
you raise the dispute on, according to you, on 510.
yes,
Now, this 510 presupposes that there was some measurement. We are trying to understand the facts.
yes. That is why, my lord, at page 93 of my claim, your lordship may come. Claim number 1, claim number 2.
Mr. Counsel for the respondent, you tell us, is there a measurement undertaken?
No, Lordship. Lordship, can we take my affidavit in opposition? Page 134, Your Lordship. Clause 9, Your Lordship.
Yes.
Your Lordship, clause 9. May I read the affirmative?
Page?
Page 134, Your Lordship.
Page?
134.
130.
Affidavit in opposition. The petitioner has been successfully completed the work in the last May. The respondent letter, file letter so and so dated at 12/7/22 was informed the present petitioner that the work is not yet completed, Your Lordship.
The contract.
As I said, because he has not done the joint verification, Your Lordship, and thereafter so many letters have been issued to place his grievance before the DRC, Your Lordship. And so many times he has been requested to done the joint verification, Your Lordship. And conveyed to your
Joint verification is risky, my lord. when we will go there, they will ask for the no claim certificate.
Entire works have been half done, your lordship. And your lordship, your lordship, kindly 154, page 154, annexure 7, your lordship. Lordship, this is the letter issued to the lordship and Chief Engineer Shillong and invited him to come to the in the place is given to the DRC. The reference is invited to this office order so and so, by which you were requested to submit the claim or statement of fact in the respect of the subject of DRC within 15 days. However, in response to your same, you have objected to composition of the DRC, your lordship, and stating that it is not valid as per the terms of the agreement by your letter dated so and so. Therefore, Chief Engineer Guwahati is by his letter dated so and so, dated 28/2/2023, addressed to you to categorically intimate that the appointment of the DRT is as per the agreement, your lordship, and your claim regarding the validity of the DRT is wrong.
Now, my lord, with due respect, my lord, I am drawing the attention of your lordship, section 11(6)(a), my lord. Section 11(6). The Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, that notwithstanding any judgment, decree, or order of any court confined to the examination of the existence of an arbitration agreement. Now, there is no dispute about the existence of the arbitration agreement. So, only requirement is that the arbitration agreement is there, then the arbitrator should be appointed.
No, the question is the jurisdiction of this court is under 11(6).
Yes, 11.
11(6) comes when you call upon them to appoint an arbitrator.
Yes.
To call upon them to appoint an arbitrator, you have to follow the mandate of the clause,
Exactly.
which is a part of the arbitration clause.
I invoke the arbitration clause. Subsequently, I invoke.
You can't invoke an arbitration clause straight away. It has it presupposes that you have to give them a notice to set it before the DRC.
I have already sent the notice within 15 days of the dispute. They failed to appoint the DRC within 15 days.
That's what we wanted to find out. We are asking you when the measurement took place.
Measurement, I don't know about the measurement.
You get the instructions. We'll take it up on 30.
Yes.
List on 30, enabling the learned counsel for the petitioner to obtain required instructions.
First week of September.
Why? Pleadings are complete on 30 September. 30 August.
30 years. Yes.
List on 30 August, enabling the learned counsel for the petitioner to obtain instructions in the matter. As to when the measurement, joint measurement of the works stated to have been completed by the petitioner was undertaken by the respondent, if at all.
Okay.
Made below. So the matter was referred to the premeditation sale of the dishonorable court matter. But mediation was failed. There is a report.
Mediation failed.
Yes, ma'am.
Where is the clause? Where is the clause for arbitration?
76, madam.
76.
Page 61. Any dispute, controversy, or claim arising out of
page, sorry?
Page 61, madam.
61. Yes.
Any 76.1, madam. Any dispute, controversy, or claims arising out of or relating to this agreement or the breach, termination, or invalidity hereof shall be settled through following mechanism. Firstly, the aggrieved party shall write a letter to the other party detailing its grievances and calling upon the other party to amicably resolve the dispute by convening a joint meeting. Accordingly, the parties, as per their convenience, shall jointly convene the said meetings, wherein minutes of the said meeting shall be prepared and countersigned by all the parties. It is mandatory to prepare minutes of the meeting and to be countersigned by all the parties, irrespective of the outcome of the said meeting. In the event the parties are unable to reach on any settlement in the said meetings, then the agreed parties shall mandatorily resort to pre-litigation mediation mechanism with Guwahati High Court Mediation Cell, Guwahati. It is only upon failure of the pre-litigation mediation mechanism with Guwahati High Court Mediation Cell, then the agreed parties shall resort to resolution of dispute through arbitration of a sole arbitrator. The appointing authority of a sole arbitrator is CMD NPCC Limited, to which neither of the parties have any objection, nor they shall ever object.
Who's for the respondent?
Responded to
Who is supposed to make the appointment? Who is the primary respondent?
Primary respondent NPCC, madam.
Who represents them? Who's appearing on their behalf?
Earlier, in the earlier order, madam, Mr. K. Gogoi, he appeared for as a CGC, my lord.
Yes, it is, I am applying for respondent number 2, Lord.
Who?
2, Lord.
Who's for one?
One lordship में notice में गए because we the lordship public sector undertaking, Lord.
Before the mediator, madam, they appeared, my
Before
lord.
the mediator, they have appeared. Their counsel appeared before the mediator.
I heard Mr. N.J. Khatoniar, learned counsel for the petitioner, Mr. K. Gogoi, learned CGC, appearing for respondent number 2.
2, Lordship, 2.
The petitioner has filed his application under section 11(6), the Arbitration and Conciliation Act, 1996, for appointment of an arbitrator to adjudicate upon the disputes between the parties. So, the petitioner was awarded with a contract. What is the contract about?
Contract, my lord, construction of composite BOP, Mikipura, company level.
Where does one find it?
This, my lord, page 16, letter of award, my lord.
For the work, so into page 16, the subject to be executed by the petitioner within the period prescribed. Stop. However, disputes arose and the petitioner has approached this court for appointment of an arbitrator in terms of the arbitration clause. That page, where is the
61, my lord.
61?
76.1.
In terms of clause 76.1. Stop. Earlier, by order dated 12/6/2024, this court, upon perusal of the clause 76, noticed that the arbitration is to be preceded by a pre-litigation mediation mechanism with the Guwahati High Court Mediation Cell. So accordingly, parties were directed to appear before the Guwahati High Court Mediation Cell and for engagement of competent mediators to resolve the dispute. Stop. Subsequently, the mediation report is received and placed in has been received from the mediator that in spite of 3 sittings being held, the case could not be resolved, and therefore the mediation had failed and the case is returned back. Stop. In that view of the matter, the actually now you should issue that notice
He said, Lordship,
to call upon them to appoint an
Lordship,
arbitrator.
Lordship. Demand is not there, Lordship, but
You have to make a demand. You have to raise in terms of the notice.
Because the clause is a defective one, my lord. That is
No.
the main issue.
Clause is effective.
Because there is a
The
provision
learned
to-
counsel for the petitioner submits that the mediation having been failed, the arbitrator was required to be appointed. However, in terms of the arbitration clause, the appointing authority, namely the CMD and PCC Limited, has been mentioned as the sole authority to appoint the arbitrator, and neither parties will have any objections. Stop. Counsel for the petitioner submits that in view of clause 12,
12.5,
12.5,
8 by 12.5.
12.5, the said clause cannot be given effect to in view of the mandatory provisions of clause 12.5. Stop. Accordingly, it submits that the application be entertained and orders under section 11.6 be issued for appointment of an arbitrator. Stop. Let notice issue, returnable after 4 weeks. Mr. K. Gugoi appears on behalf of respondent number 2, and therefore notices are waived. Extra copies be furnished within a course of 1 week from today. Steps on respondent 1 by usual course and registered post. Custody is also permitted. Matter be listed after 4 weeks.
Obliged.
My lord, in this case, counter affidavit has been filed by the respondent. I want
Yes.
2 weeks time for filing the rejoin.
Mr. R. Hussain, learned counsel for the petitioner, submits the counter affidavit is filed in matter and he requires 2 weeks time to file the rejoinder affidavit. Is it covered by the same order?
No, my lord.
Covered.
As per his version, it is covered. As per my version, it is not covered.
All right.
My case is covered by different judgment. He is saying it is covered by different judgment.
You file your rejoinder.
And he is relying on a judgment which is under challenge in the Honorable Supreme. And I am relying on a judgment which has got its finality. And then thereafter, a recent judgment of the Honorable Supreme Court is there on that.
Regarding that Stamp Act,
No, my lord.
registration and arbitration.
No, my lord. In interplay between arbitration and stamp act. Thereafter, my lord, recent judgment has come. SBI insurance, my lord.
All right. Yes, 15, yes.
On last. Yes, Lordship, as we have to file our objection, but after communicating with the client and all, as we have come to know, Lordship, as there are lapses from the petitioner side. So, Your Lordship, we are agree with the prayer that if she is ready to provide us the document, then we are ready to do the construction. We can start the construction.
What lapses? You file your affidavit.
That's what.
You make or whatever you want to state, you state it. Why are you shying away? If you're not interested, we are closing your right to file counter.
Then Lordship, I'll bring on record, but Lordship, is just the appointment of the arbitration here.
The arbitration is because of the dispute. If you say there is no dispute, we are dismissing the petition. And you are shying away from filing your counter.
Then Lordship, I'll bring on record. I'll file. I'll
You file it within 2 weeks,
Yes,
no
sir.
further time.
Yes, yes.
If you don't file it, we are closing your right to file counter. Heard, learned counsel for the parties. Respondent is permitted 2 weeks further time to file their objections / affidavit. It is made clear if affidavit is not filed within 2 weeks from today, court will proceed to hear the matter on the basis of the pleadings available in court, available in the
Right.
report.
Right.
List after 2 weeks on a date to be fixed by the registry.
May I please? Lordship, I am appearing for a sole respondent. 4 weeks time may be granted. We are filing a counter matter.
Yes, Mr. Rahul. Mr. Rahul appears for the petitioner, Mr. Puragwai appears for the
Our secretary.
uh, appears for the respondent, sole respondent. Uh, he submits that he would require how much time?
4 weeks time.
4 weeks time to file his objection / affidavit. Prayer is not objected to by the counsel for the petitioner, least after 4 weeks on a date
Can I
to be fixed by the
pray for a
registrar.
date? May I pray for a date?
After 4 weeks, give a date. Give a date after 4 weeks. 20 September. Mr. R.S. Puragwai.
May I please, your lordship, the affidavit is sent for vetting, so kindly some time may given to file our
Counsel for the, yes, any objection?
No objection, my lord. They can
Counsel
file.
for the respondent submits that the affidavit is under preparation. They would require further time of 2 weeks to file the affidavit. I may send here, learn counsel appearing for the petition does not object to the made list after. Vetting is not a ground for adjournment.
They can be given only 1 week and answer be given after least, after 2 weeks.
We are giving them 2 weeks in view of some holidays in between.
It's fine, my lord. But if only vetting is required, then they can file within 1 week. Next week, only Friday is listed.
We are not even taking into consideration the aspect of vetting. This is between them and your clients. Don't tell us. Don't tell us that you are sent it for vetting. You have drafted it, you have sent it. Are the clients going to tell you whether this affidavit is correct or not? You are the lawyer. You decide what goes in. Yes, Mr. Gogoi?
Come next week, even we can file by Monday also file.
Why you have sent, we don't know.
Lordship.
You have sent, so we are
Lordship.
giving you 2 weeks time.
Lordship.
But this vetting
Lordship.
is my personal view.
Lordship.
Yes. Yes, sorry. I wanted to point out one aspect of this matter. You come to clause clause 12. Kindly have a look at clause, of the Arbitration Act. Section 12, sorry.
Yes, lordship, grounds for challenge.
Yes.
When a person is
So
approached,
if the person is approached, so the consent he has to give it. You have to approach him, get his consent, and then we pass an order appointing him if there is no handicap. Instead of appointing him or her and then trying to get a consent to be told that they are handicapped under section 12. Therefore, the matter comes back again for reconsideration. So you get their consent. The section is very clear. When a person is approached in connection with his possible appointment, then he shall disclose in writing the following circumstances.
Well, my lord, 12.
Section 12, 1.
lordship, section 11(6) clearly says that this honorable court has the power to appoint. It says that where under an appointment, subsection 6, lordship,
No,
where under an appointment
E-
procedure agreed upon by the
11 is
parties.
clear, but 12 this declaration has to be given by the arbitrator.
Lordship had passed the order that on the last occasion, as far as I recall, that
Yes, we had. Then we
yes,
noticed
Lordship.
section 12.
The consent part also your Lordship had
That's right.
given.
That is overlooking the mandate of section 12. Therefore, the matter is listed today.
Lordship.
We had closed
Grounds
your
for
matter, but without the consent.
Should be taken prior, my lord.
Prior.
My lord, another thing it has come to my after the lordship that day. Another thing has come to my notice, my lord. Notification of High Court, my lord, where C.R. Sharma's name is there, that is C.R. Sharma, and H.K. Sharma, the other person, sir. Full name
No,
I
this is
forgot,
not.
B.S. Sharma.
No, this
That
is.
is not.
This
It
is.
I have to
a
only
matter of.
point out, my lord,
No, this is
that
for a
there is
matter.
another notification
Ah.
showing the names of the persons who can be appointed.
That's
It
right,
is
but
not-
that is for a matter of reference. It's not binding.
Then,
It's
my
not
lord,
final.
okay, my lord. Then it has come later on. It has come to my.
No.
This notification will apply in cases where your Lordship is appointing a particular arbitrator, but so far as nomination is concerned,
If the parties choose,
parties choose,
Then
it is
it's-
permissible.
then it has to be allowed. The only thing is that we permit both parties
Lordship.
to approach the
Concerned person
concerned
nominated.
arbitrator that you have in mind and get a declaration from 12, under 12, place it before us and we'll close it. That was the only reason.
Lordship, within 2 weeks.
Within 2 weeks.
Within 2 weeks.
All right.
It's a long pending dispute.
I know.
I-
Third learned counsel for the parties. Counsel for the petitioner submits that Justice Brijeshwar
Visheshwar Singh.
Vishweshwar Prasad Singh has been nominated on behalf of the petitioners to act as an arbitrator on their behalf, on behalf of the petitioner, and Justice C.R. Sharma, retired, both are retired, has been nominated as an arbitrator to represent, nominated by the respondent, GMDA. Stop. Under such circumstances, the parties are permitted to intimate the respected arbitrators which they propose to nominate and are required to be appointed under orders of this court to accept their appointment in the event such orders are passed by this court in terms of section 12 of the act. The disclosures as and when disclosures under section 12 as required may be placed before the court on the next date by the respective arbitrators. Disclosures by the respective arbitrators. Matter be listed on is 30 August good enough, or you want a later date?
It is the first week of
6th of September. 6th of September. Is not 6. Yes.
May it please your lordship, the respondent side had taken time to file an appropriate application before this court. Actually, the arbitration agreement is in page number 17. The relevant portion
Who is for the respondent?
one is
Anyone for the respondent? Please scroll out the names of the respondent counsel. This is item number
20.
20. Roll out the name. We'll call it up after a while. Wait
Obliged.
for some time. Respondent counsel. Enough.
My lord, 1 week time may be granted for filing rejoinder.
Rejoinder.
Almost it is ready, only 1 week.
Yes, respondent. Mr. R. Hussain, learned counsel for the petitioner, raised for and is granted 10 days further time to file rejoinder in the matter. Mr. S. S. Roy appears for the respondents list after 10 days.
All right.
Here also the same thing is necessary, that requirement of section 12.
12 lot.
So you approach the arbitrator in question and get a disclosure from in terms of section 12. Heard learned counsel.
Heard.
It is submitted. It is agreed between both the parties that that an arbitrator be appointed by this court. Notification. What was the name of the gentleman? B.K. Das.
Lot 19, serial number 19. Yes, sir, PK Das.
B.K.
BK Das. Mr. Pani.
Mr. B.K. Das, chief engineer, who is also an advocate, and whose name appears in the serial number 19 of the notification number so and so, published by the Registrar General of the Guwahati High Court, is sought to be appointed as is agreed upon by the counsels for the parties to be appointed as an arbitrator to decide on the disputes arising by and between the parties. Item number 19, serial number 19. The parties, the petitioner will approach the learned arbitrator, will approach the learned arbitrator who sought to be appointed by orders of this court as required under section 12 of the Act, and any disclosure that may be furnished by the learned arbitrator shall be placed before the court by the next date fixed. Based on when can you
on 11th of September.
11.
September.
No, I think it was 13.
Okay.
When was the other matter?
Yes, sir, 13, sir.
13 September.
That
Based
was
on 13 September.
sir, one submission. If order is not signed, can some change can be made, Lordship?
What change
The
you want?
change is that there is need not to call for record from old arbitrator to sending a new.
No,
That we will.
that will come later.
Acha,
Not
okay,
not
sir.
now.
Okay.
Yes.
Obliged, Lord.
May I please the lordship, my lord?
Yes, yes.
My lord, in this case, what happened, my lord?
Where is the APP? You are the APP.
No, I'm the informant.
Where is the APP? Call for the APP. Just wait for a while. Next matter. You have filed the affidavit. Additional affidavit you have filed. What do you say? Who's for the education department?
Lordship, I have to go through and verify the same, Lordship.
All right. Mr. Hussain, sorry, Ahmed
Yes, sir.
Ashok, sorry, appears for the petitioner and submits that the additional affidavit has been filed in the matter. Counsel appearing for the respondent submits that she would like to complete her instructions with regard to the particulars reflecting the employment of the petitioners in the affidavit. She prays for 3 weeks' time.
Lordship.
Lists this matter again after 3 weeks.
Obliged.
Eh, Mr. Todi will take it up at the end of the board. Last member. Yes.
May I please, your Lordship? This arbitration petition is regarding appointment of arbitrator. Now, I am before this honorable court under section 11. Now, here your Lordship will kindly see, there was an agreement with, in fact, there was pre-agreement with the railways. Lordship may kindly come to page number 21. In fact, it starts from page number 20, the agreement. The pertinent portion is in page number 21, paragraph number 5.6, which contains an arbitral clause. Lordship may kindly find it. In any case of any dispute, the matter shall be referred for arbitration to a sole arbitrator to be appointed by senior DCM LMG division NF Railway. A sole arbitrator shall be an officer not below the rank of they have not mentioned, who has not dealt with the case earlier during the course of his duty. Now, what happened, Lordship? I filed an application under 21 because they have never appointed any arbitrator. They have, in fact, I was having a stall, Lordship, in the platform number 1, and that stall, that other stalls were demolished. For that, Lordship, I filed one 19 petition, section 9 petition before the district court. The district court being the court of the first civil instance. And there the court has given a status quo, but in spite of that status quo also, they demolished my top, and I was removed from platform number 1. Thereafter, what happened, Lordship, I am before this honorable court, Lordship, for appointment of, I have annexed the.
Where is your demand for an appointment of an arbitrator?
That your Lordship will find it. We have given a notice under 21 for appointment of an arbitrator. That your Lordship will kindly find in page, annex number 3, page number 28, Lordship. Notice under section 21 of the arbitration and conciliation in so and so to the agreement so and so. To this, Lordship, they reply. They give a reply to us stating inter alia that since you have filed a writ petition earlier, that your Lordship will find in annex number 6, page number last page. Should be, if I am not wrong, it should be 46. Wrongly written in my. Your Lordship will kindly find that I am totally putting emphasis on this letter. Why reason? I will say, Lordship. In response to your notice mentioned under reference, it is to inform you that before appeal of arbitration under 21 of the Arbitration Conciliation Act, as per CA dated 21 dated February 7th, you have filed writ petition before the Honorable Guwahati High Court before arbitration appeal. Hence, your appeal for arbitration is not considered. Now, if that is so, whether railway will have any right at this point to come and claim that they will appoint their arbitrator. If they are saying that I have no right, they to claim for an arbitral appeal.
What is this WPC 57789?
Lordship, WBC was filed by us.
Then what happened there?
challenging all the atrocities that has been done by them.
Uh,
Subsequently, this WPC was withdrawn. And now they are saying, since you have withdrawn the WPC, you don't have any right under the Arbitration Act. Arbitration Act is a statutory act. It's a statute which gives us a power. Now, they are never willing to appoint an arbitrator. They have been delaying this matter. This is a matter of 2019. And after this letter being sent to us, the Lordship may kindly see the date, 17/7/2021. The Lordship has kindly got the date, Lordship. This letter. Now they are holding
page.
page 56, the last annexure 6.
Hmm.
This letter was sent to us, dated on 17/7/2021.
Hmm.
Lordship may kindly see. That was the period when the COVID scenario were almost in a fray at that time. And at that time when the COVID scenario was in a fray, they have demolished my shop and they have removed me from all my earnings. Lordship may kindly see that here they are saying 10,46,549.80 so and so, so and so. But till date, if they are claiming that this is your outstanding, let me take for a moment of time that this is my outstanding. But till date, they have not appointed any arbitrator. Let me forget that I have come for appointment of an arbitrator because I'm disputing this amount. They should also have gone for an arbitration because there is an arbitration clause. Therefore, they cannot go for a civil court. They have also not exercised their right for recovery of this amount of money. But whenever I come, they say, no, we will appoint our arbitrator. Now, in light of this letter, which has been issued by them, my submission before Lordship is this, that they have precluded their right of appointing an arbitrator. And that is I am before this honorable court for appointment of an arbitrator from the panel of this court. And if an arbitrator is appointed from the panel of this court, Lordship, they are not going to be prejudiced. 100% there will be a fair decision will be taken. Why they want to appoint an arbitrator from their own panel?
Yes.
Lordship, I would like to humbly draw your attention to the prayer portion of this particular petition that has been filed, the arbitration petition. Lordship, here I would like to read the prayer portion which has been incorporated here. It is therefore prayed that in page 11 of the arbitration petition filed by the petitioner. Your Lordship.
Yes.
It is therefore prayed that your Lordship would be graciously pleased to admit this petition, call for the record of the case from the office of the Divisional Railway Manager, Lumding, issues Chopos notice calling upon the respondent as to why this honorable court, by exercising its power under section 11(4) of the Arbitration and Conciliation Act, shall not appoint any learned arbitrator in view of the fact that the respondent, having failed to appoint arbitrator on their own, and after hearing the parties, be pleased to appoint learned arbitrator as per the provision of section 11(4) of the Arbitration and Conciliation 1996 to secure the end of justice. Your Lordship, here, nowhere the mention has been made regarding who will appoint the arbitrator. It's
11
regarding.
11(4), let us read. 11.
Let me finish, Your Lordship, my part. Your Lordship, here the prayer is very much specific regarding the appointment of the arbitrator, and most relevant thing is that, Your Lordship, number of SLPs have been filed, Your Lordship. Here in the recent judgment, arbitration case number 15 of 2023, which has also regarding the judgment of this honorable court, which has said regarding the appointment of the arbitrator can be made by the honorable court, that has also been challenged before the Supreme Court of India. Your Lordship, that document I have with myself, which have been provided by the department. Your
No,
Lordship.
now this provision of 12.5 will apply.
11(5) and 11(4) both will come.
Who is, in terms of the agreement, who is supposed to appoint an arbitrator? Railways.
Railways.
So you can do it under 12.5. There's a bar.
Failing any agreement, refer to subsection 2.
But the SLPs that have been filed, Your Lordship, those are still pending before the honorable court.
No, but the law as it stands today, 12.5 has been upheld. 12.5 has been upheld. Then Law existing today will be applicable.
Your Lordship, regarding the previous SLP, Lordship had asked for an update for regarding this matter. It has been pending for final hearing on 30th/7/2024. And recent SLPs have also been.
There are
filed against-
judgments under 12.5, Mr. Bhattaji.
Lordship.
You don't have that.
Rightly, I'm not having that, but I can come out with those.
So if you can come out, then why did you start the argument if you're not ready? Unless you are ready, don't start your argument. Matter stands deferred to be listed after 4 weeks. Meanwhile, the councils will update the court, apprise the court in respect of the status of the matters stated to be pending before the apex court. List after 4 weeks.
Diplomatic.
Obliged.
Yes, some review.
My lord.
They are agreed by only one observation. You are agreed by only that observation.
Yes, I will take your lordship to that part at page 45. I'll read from my lord
44.
page 43, para 20, my lord.
The observation at page 44.
At 44, my lord.
Yes.
Now, if your lordship take that part, my lord, that part, the amount which was withdrawn, which is stated to have been withdrawn from the RIPC account without the petitioner making the deposit, also had initials of the manager and other officers. This will go to show that there are other officers entrusted with supervisory, administrative, or managerial responsibilities who are supposed to verify and check every transaction which took place in the bank, including deposits and withdrawal of money. There is no material placed before the court to show that along with the petitioner, there are other officers or employees of the bank who have also proceeded with and or imposed with penalty. In any view of the matter, the amount which was found to be short paid by the petitioner relates to an RIPC account which was opened in the name of the petitioner himself. It does not belong to any other depositor of the bank. For the aforementioned reason, the opinion of the court, the punishment of removal from service without disqualification for future employment appears to be harsh and compared to the charges level against.
You
the
are agreed
petition.
by this observation.
Now, my lord, if your lordship, this observation, my lord, actually, my lord, there is, your lordship directed us to place the record where the other officers was, a disciplinary proceeding was proceeded against him. And my lord, that was placed before your lordship.
No, how does it alter the judgment? How
My
will it
lord,
alter
that,
the
I'm that.
conclusion?
Now, your lordship, given a finding, this will go to show that there are other officers entrusted with supervisory, administrative, managerial, because we did not take any action against those officers. Therefore, we cannot only, my lord, implicate this person. Now, your lordship,
We
can
are not
see here,
interfering with the punishment. We are only altered.
that
We
has
did
been
not
altered.
interfere with the proceeding.
But my lord, the law is abundantly made clear by the appeals court.
Hmm.
If you are found that you have misappropriated, then my lord, the only punishment is either
In respect
dismissal
of
or
an account opened in his name.
my lord, he has written all the vouchers in his own name, and he has opened an RIPC account without depositing, and that amount belongs to the public money. And if the public money is squandered like that, my lord, in a banking institution,
File an appeal.
my lord, that is the area, my lord, I am aware of. But then since factually that part is not correct, because the other officer, that is Bankim Sharma, the disciplinary proceeding was initiated against him, he was punished. So my lord, what we are thinking, that this fact was missing here, that your lordship persuaded, because the Your lordship has taken a view in this case based on 4 factors. That was one of the factors. Now, on this, having regard to these 4 factors, lordship has taken a view. That view cannot be a subject of review, my lord. Any amount of Supreme Court judgment will not end. My lord, a review under 226 is also under, as a petition is under 226, review is also under 226, and as a court of record, lordship has inherent power of review. That's not. Question is, 4 facts were taken note. Now, one of them happens to be this. Because why I'm saying so, my lord, now immediately after that factor, lordship says, in any view of the matter, amount which was found to be short paid by the petitioner refers to an RIPC account which was opened in the name of the petitioner himself. So therefore, several factors were taken note of to form that opinion. So this opinion that he is a very lowly paid employee, he is a grade 4, he is not involved in the decision making. Therefore, it will be too harsh to dismiss him from service. Therefore, to impose the punishment of compulsory retirement, it cannot be a subject matter of review. Yes, if my learned friend can persuade the appellate court, it could be a very good case for appeal. But under any circumstance, it cannot be a ground for review. Below. At least review jurisdiction does not permit this because it will amount to rehearing the whole appeal petition, my lord, in the disguise of a review petition. Then I optimum number of judgments.
So for that, my lord, I am well aware. That is the area where the appellate court will see. Now, my lord, since, my lord, what was in my mind, because the some factual part was missing. And if we yet to it, my lord, if your lordship, for that limit, no, for that limited purpose, what I was thinking, your lordship's view was that since the officer concerned is the main person, he was required to sign all these vouchers. He did not, and the bank found that he was negligent in discharging his duties. The disciplinary proceeding was on, and he was found guilty. Punishment was given, and your lordship thought that bank did not take any action against him. Therefore, we hold up only these petitioners. Now, even my lord, other part of the thing, my lord, it is the area of appellate jurisdiction. That is, I am well aware. But if your lordship take into consideration this part, then my lord, if this part is taken into consideration, then the review jurisdiction comes in because that's the reason, my lord, I was trying to take your lordship to para 89 and 90. Now, my lord, one thing that can be done. My lord, in that case, what my submission would be, so for factual misapprehension is there, that may be corrected, and then, my lord, so for appellate forum, whether they want to approach or not, it is up to my client. Because I cannot go into all that because of the fact that review may not lie to that extent. My lord. Now, that was my idea, my lord. I'll read once again that part. The amount which was withdrawn and which is stated to have been withdrawn from the RIPC account without the petitioner making the deposit also had initials of the manager and other officers. This will go to show that there are other officers entrusted with supervisory, administrative, or managerial responsibilities who are supposed to verify and check
every transaction which took place in the bank, including deposits and withdrawal of money. There is no material placed before the court to show that along with the petitioner, there are other officer or of the employee of the bank who have also been prosecuted and or imposed with penalty. In any view of the matter, the amount which was found now, your lordship was in mind that the other officers, there was no disciplinary proceeding. Only one officer, Bankim, he is the manager, my lord, at that relevant time.
One increment.
No, initially 5, then it brought down to 2. He is Bankim Sharma, my lord, Bankim Sharma. He was manager.
No other officer is
No,
entrusted.
he was the only officer. And otherwise, my lord, if we go to the merit, my lord, your lordship will find in the disciplinary proceeding, what happened, he did not, even my lord, he did not give any evidence himself. He said that I instructed the manager to deduct the amount from his account, but the manager did not do it. He could not prove it in the disciplinary proceeding. Even he did not give any evidence. Mere saying will not do. There's a pleading only. He is required to give your evidence. Even he did not cross-examine the witnesses of the bank.
That's honest.
All right, we'll
My lord, only thing is I am a very lowly paid man. In spite of the judgment, nothing has been paid to us. Even if your lordship is inclined to examine, let lordship clarify that there is no stay on so that I can get my benefits.
there's no stay.
Yes,
It doesn't require clarification. There's
Yes.
no stay.
yes.
So,
Lordship may keep it at this stage
I-
another day.
I will keep it. What I want to know is what is the process? How many officers are involved? Or
My lord, in our affidavit in reply, we stated that Bankim Sharma was proceeded departmentally only to increment with awarded period. Withholding of 2 increment.
not that.
Yes.
In this
And
process-
other than this, nobody else was, charged. It can't happen, can't so happen, my lord. The accountant would be there,
That's right.
the concerned
So
clerk would be there.
Therefore,
Yeah.
assuming this view is corrected,
Ah.
there would still be other officers
Yes.
involved who have not been prosecuted.
Yes,
against.
yes.
So essentially, the conclusion is
In
not
fact, in my lord, GC Sharma's case, which is a case from our High Court, which eventually went to Supreme Court. Supreme Court says you just cannot pick up one fruit from the basket. If you feel the basket is rotten, then whole basket will go. You can't say that the particular fruit is bad.
So you tell us by the next date, if
My
possible,
lord, my lord, we'll do that.
that how many officers ordinarily would be involved and against whom the proceedings are there.
Yes.
We'll correct it. But we are making it clear we're not inclined to change the view. Because
We'll
that
have
will
that.
amount to rehearing the matter again.
No, that I understand. But then, my lord,
But yes, you are correct that factually, if the records reveal that proceedings were initiated against one person, at least that requires to be corrected because
Inserted.
for the
that.
records. For the records. We can have it on Thursday or some other day. if you-
Next Thursday, my lord.
No?
next week, my lord.
But next Thursday, oh, wait a second.
Sorry, next.
Not the following week, my lord.
All right. Then on 30th,
Yes,
30.
yes. please.
30.
My lord, 30, my lord, I'm in
Kohima.
No, I do not know why, but a bit uncertain, my lord.
But you are certain you will not be here.
No, he has already given his words, I'm coming. My lord, material instruction has not come. My learned friend also equally posted. Is sometimes Itanagar, sometimes Kohima.
All right, then we can have it on 6th,
Oh, yes.
6th of September.
My lord.
It's Nalabade, I have told my friend not to give any brief on 6.
He should follow that also.
That principle is not applicable to senior council, so the matter be listed again on 6th of September. An attempt will be made to dispose of the matter on the next date fixed.
Only thing, my lord, world is full of angry people. My learned friend, one of them.
Display here then. Huh? All right, hard. Me or Mr.
G. Kaushik.
G. Kaushik, learned counsel for the petitioner. None appears for the respondents in spite of the names being reflected in the cause list. Stop. As per the earlier order dated 17/7/2022, 2024, 2 weeks time was granted to the respondents to file necessary affidavit in objection, affidavit in opposition or objection. Stop. However, no such affidavit or objection has been filed as on date.
Lordship, they have filed an affidavit in objection,
They have.
but some
Then?
proper application they wanted to file to implead a party.
Sorry?
They wanted to file an application to implead BCPL in this case. That was the issue.
Then you write, have filed their objections, affidavit. Is there any rejoinder required from your side? No.
No.
However, an application for impleadment was sought to be filed, which has not been filed as on date. Accordingly, matter be posted again on 30 August, on which date the court will proceed to hear the matter. The court will make an attempt to hear the matter and dispose of the same. Yes, what is to be done here?
There was an order. There is an order in this case, Lordship, that as the search has not been claimed, Lordship, so the bail has not been made absolute, Lordship. So charge is not yet claimed, Lordship.
I am on interim bail, my lord, as per direction of this honorable ITR.
There was some application filed for cancellation of the bail.
Yes, ma'am.
Where? Before this court.
Before your lordship. Do you have filed it there? That has been rejected, my lord. In the other court, my lord. Other court.
Well, in that case, the heavy fine has been imposed against them because they have suppressed the matter that they earlier it was rejected. They filed prestige there and they got the bail by suppressing that very fact. We have brought that matter to the knowledge of the Honorable Court. Honorable Court has imposed 10,000 rupees each. 5,000 is as cost, my lord.
I am the only person, my lord, who has, my
And
lord.
they are still inside the jail. They are not paying that cost also.
That is, they are not paying 5,000. That is why they are inside this jail. And in this case, my lord, my humble submission before your lordship is that, my lord, the persons whose bail has been rejected along with me, my lord, was released by this honorable court, my lord. All the person is releasing on bail, my lord. Someone has not paid fine. That is why they are inside there. That is different aspect of the matter. I am relying on one judgment of the apex court, my lord.
Otherwise, Lordship, he is an interim bail, Lordship.
Hmm?
He is
Here
an
in this
interim
case,
bail.
my lord, earlier it was rejected by your lordship. 438. Again, they have come 438.
I'm mentioning all these things in my petition, my lord.
Hmm.
And interesting thing in charge sheet, my lord, not a single allegation leveled against me, my lord. And if last time verified, my lord.
Why charge has not been framed?
Initially, my lord, charge sheet was a part charge sheet. Now it is final charge sheet has been filed.
When
Now-
was it filed?
Yes, Lordship, I have not found in the record, Lordship.
But we have come to
No, I have,
Yeah, what-
charge sheet has been there, my lord. I have an
Charge sheet
X. Yes, my lord.
Final Lordship is me. Final कौन है?
No, it doesn't look at the part charge sheet.
Ah.
Look at it too. That's it. That has been fixed for appearance. We
When
appear.
is the date fixed next?
Next is kete hoche? Eitla lagbe.
There is a report, Lordship.
When I was my lord released on interim bail, my lord. That has been fixed for appearance, no?
There is a report, Lordship, and in that report also it is stated, Lordship, that he is regularly appearing in the court on the 2 or 1 or 2 days he is appearing, and as per direction of this honorable court, he is allowed to go on bail, interim bail, and now he is appearing in the court, Lordship. There is a order, but why charge is not same?
What is your ground for objection?
My ground is that when they have come before your lordship with a second application, practically there is no new ground. Earlier ground that you have, for which your lordship has cancelled it. They have not.
What was the order passed earlier?
Page 28, my lord. May I start my case? Page 32.
Yes.
Your lordship. Considering the gravity of the offense, LS. Have you lordship got it? Page
Yes.
32. As severity of the punishment prescribed, if considering the matter is still under investigation. That is why bail has been. And that charge
It's
sheet-
only for charge sheet not being filed. It
Yes,
was
that is why
cancelled.
rejected. Subsequently, charge sheet has been filed. I approached before.
What is the next date fixed? Next date.
My lord?
What is the next date
Next
fixed?
date to Thana. Right?
January.
And if your lordship go to the content of this charge sheet, not a single allegation level against this petitioner.
My lord,
161 statement not mentioned, my lord, anything. It is a
Is
good
it-
case
is
to
it a
us.
part
we
of
have
the,
lost 2%.
Yes, my lord.
2% of our family.
the
We
matter
have
is on
lost, my
trial?
lord.
Now, where is the charge sheet here?
Yes, my lord. May I read the charge sheet, my lord?
Yes.
Yes. Yes, my lord. Yes, 39, my lord.
The part charge sheet, the final charge sheet has not come.
Brief favor of the charge sheet is that, my lord.
Page
Page 39, my lord.
39.
The thing is that, my lord, before that, I am the, there is a group fight between the parties, my lord. In my side, my lord, 1 person has been died. My learned friend's side, another senior friend's side, another 2% has been died, my lord. In the meantime, this thing, my case is that, my lord, at that time, I was not present, my lord. There is 161 statement, if your lordship verified, not a single witness has said, I was present in this case. Only because in the FIR, my name has been mentioned along with 34 more person, my lord. I was, my lord, made charge sheet in this case. May I read the charge sheet, my lord?
Yes.
Brief fate of the charge sheet is that last on information is Sariful Islam Hasmut Ali or Koloibari Sorbok, Porpeta Assam informed the Sorbok police station by lodging a FIR against the accused person, Muhammad Ali, Rashid Ali, Sarab Ali, Ali Hussain, Karim Ali, Jahangir Ali, Abul Hussain, Surat Ali, Sisir Ali, Baharul Ali, Abdul Aziz, Abdul Bakkar, and Abu Siddiqui, Abul Salam, Abul Hussain, Abul Salam, Soifur Rahman, Kodur, Atwar Ali, Tiger Ali, Mohidur Ali, Abdul Salam, Basar Ali, Baten Ali, Salman Ali, Amjad Ali, Baskar Ali.
Where is your name?
My name is my lord mentioned in there. My name is not mentioned, my lord. Subject to correction. Your lordship, my name has been mentioned in 47, my lord.
Your petition, you are asking the respondent whether
No, my lord. Sometimes they said, my lord, yes, my lord, keep the name. That is why I'm asking.
he is giving you an opportunity to point out his
Yes, my lord. Yes, my lord. 47. accused,
47,
yes, my lord,
47,
where my name has been mentioned,
page 47.
page 47. Accused person damaged the Yamaha motorcycle by setting ablaze, by which this is Hasmond Ali came and people informed setting ablaze house, and as a wife, all effort were made arrest the accused person Sisir Ali, Abul Latif, Odura Ali, Adir Ali, Atar Ali, Abu Sadiq, Soifur Ali, Lalbor Ali. That is my name, Lalbor Ali, my lord. But in unknown place, all the investigation almost completed, but the blood stain, stick, sword seized in connection with the case were sent to FSL Guwahati for forensic examination. A report of the same were not received. CDR of accused are yet to be collected. Therefore, after receipt of FSL, their final charge sheet will be complete. Because this FSL report, other were not found. That is why it was, my lord, they have said charge sheet has been not been filed per charge sheet. Because they have, perhaps they have filed this charge sheet, my lord, because this is the charge sheet has been filed, my lord. 120 be
In
extended.
fact, my lord, final charge sheet has been filed on 4/3/24, which is not in the record. Final charge sheet.
You bring it on record.
Yes, my lord. My humble submission is something different, my lord. Except this petitioner, my lord. All this person and other person is released on bail. I am the only person, my lord, who has informed before this court, my lord, that my bail application was earlier rejected, this ground. And my lord,
Which is why we are giving you interim bail.
that is why interim bail, my lord, I
entering
recollect,
interim
my lord, one story of Mahatma Gandhi. He cattle word, my lord. The teacher say write down like this. He did not write down there. That is why, my lord. This thing has been happened to me also, my lord. And I have given the similar case, my lord, Kamaljeet Singh.
No, but you're on interim bail.
Yes, yes.
So
Nothing to worry.
that
Next day, 22/8/2024.
22,
8/2024.
next date.
Production of accused, no? Production of accused.
But why charge has not been framed? In
Because
spite
of-
of charge sheet having been
No,
filed.
my lord, perhaps, my lord, all the documents were not submitted before the court, my lord. My Ranish.
No, it is filed, my lord. Final charge sheet filed on 4/3.
Not there. That is
4th
why
of March.
it was fixed.
APP, please get a report why.
Kindly, yes.
File.
Registry will call.
That registry will call for, but your investigation has to tell us why the charge sheet having been filed. What is the step? Why the
Whether charge sheet
charge
filed or not, also that I can take this instruction.
Yes.
Whether the final charge sheet or filed or not.
That is our instruction 4/3.
As per their information, it is filed. But I will take instruction also whether it is filed or not.
Third, Learned Counsel for the party. Learned APP will apprise this court as to when the final charge sheet has been filed. If at all. This
It is
information be placed before the court on the next date. Meanwhile, the registry will call for a report from the
And regarding final charge sheet, can be called.
competent court. Call for the scan copy of the final charge sheet filed and a status report as to whether any charge hearing,
Same not.
whether charges have been framed by the competent court in the meantime. Give us a date.
And again, September, yeah, and
September 6th on 6th of September.
can it be 9/9?
9.
Monday.
The date is beyond 13th,
Yes.
13th September. It's not 13th September. Copy of this order we brought to the notice of registrar.
My problem.
Series of matters in the same, which is fixed. This is for refund.
Yes,
Yeah. Okay. All right, we'll pass orders.
Lordship has also on a similar issue, passed an order. Lordship, I'm giving a copy. Lordship. Lordship, Rajendra Kumar Devra versus State of Assam. There also, Lordship, initially the assessing authority rejected it. They went on revision. There the explanation was given in the rejection order.
We'll go through it.
Yes.
Are you aware of this judgment?
No, Lord.
Then you go through and tell us on 30th.
Lordship has taken into consideration the Bhatek, and Bhatek Lordship has dealt with it, and another
It's in
one.
similar lines.
Similar line, Lordship.
Conclusion I've read on the same line of Bhatte.
We don't want, if you want time to go through this judgment, take your time. We'll fix it up on the next day. If there's anything more to be added, you submit before us. We are not compelling you to accept this judgment.
Otherwise, my submissions were placed before Lordship.
We have taken note of your submissions.
Lordship, my only
Phone number 5. 2 number है, पहले वाला.
the only submission was that for Lordship has it has fallen from Lordship that for consideration, my only prayer was that direction should be there for refund in a time-bound manner rather than directing them for consideration. That was the only prayer.
We'll
expressed
examine
prayer.
that. Do you want time to examine the judgment?
I'll go to Lordship. I'll go to.
Then we'll take it up on 30. 30. 30 or on 6.
30 August.
Yes. Matter to be listed again on 30 August. Attempt should be made to dispose of the matter on the next day.
Report 1 and D.
itu Bhatekৰ লগতে সেইটো বেছ কৰে নিশ্চয় একো নাই মই চাই থাকোঁ
এনে কনক্লুজনো পালো কনক্লুজনো পঢ়ি ললো লাষ্ট
ভাল হ'ব পাৰে